At Raju Law, we don't just provide legal services. We provide a pathway to your American dream. With offices in New York, Los Angeles, Washington, D.C., Atlanta, Dhaka, and Dubai, our global team is dedicated to delivering personalized immigration solutions. Whether you are pursuing a green card or navigating complex immigration processes, we are here to guide you at every stage. With a team of 10 associate attorneys and more than 180 law clerks and case managers, we craft solutions tailored to your unique needs. Our technology-driven platform ensures the fastest, most efficient service, saving you time while upholding the highest standards of quality. At Raju Law, we believe in affordable, transparent pricing without compromising on service excellence. Raju Law, where your American dream meets expert legal support. Contact us today.
Good day, everyone, and welcome to our Monday live session. I am Manshi Katira, Assistant Manager at Dubai branch of Raju Law, and I will be hosting today's session. Thank you all for joining us. Today, we will be discussing understanding the EB1a, one of the most prestigious US immigration categories, also known as Extraordinary Ability Visa. We are honored to be joined by two discussed guest, Chelsea Smith, supervising attorney at Raju Law, who has extensive experience guiding applicants through extraordinary ability petition. Alexander, associate attorney and team lead at Raju Law, known for her expertise in complex immigration cases and helping clients achieving successful outcomes. They will be sharing their knowledge, insights, and practical tips on EB1A process.
Thank you, Mansi, for this great introduction, and thank you everyone for being here today. We are happy to have this discussion with you about the EB1A visa option. I think up until now, we've been talking a lot about the EB2 and IW. That's usually a topic of hot discussion for prospective clients and prospective applicants. But today we are coming to you with the EB1 visa presentation to discuss how maybe you can self-assess some general characteristics of the EB1A, how you can, look at your own portfolio and determine maybe you could qualify for this exceptional, it's really extraordinary visa requirement. So without further ado, I have Alex here today. She is going to lead us through this discussion, and we invite you to ask questions relevant to the presentation at the end of our time together.
Yeah. Good morning, good evening, depending on where you are today. So we'll be talking about the EB1A visa, and we'll go through the 10 criteria, which is one way to qualify, and we'll hit some talking points on those and hopefully prompt you to start looking into whether you would qualify or not. So to start, the EB1A visa is an immigrant visa for individuals with extraordinary ability in the arts, science, business, athletics, or in education. And if successful in applying, you qualify for a U.S. green card, as does your spouse and any unmarried children under the age of 21. They may also obtain a green card through your EB1A approval. Additionally, I'd like to note that EB1A visa is a self-petition, meaning it does not require a job offer or a labor certification. To qualify for the EB1A, a petitioner must demonstrate that they have extraordinary ability and that they will continue to work in the field in which they have extraordinary ability while they're in the U.S. So defining extraordinary ability, that means that you have a level of expertise indicating that the individual is one of that small percentage who have risen to the very top of the field of their endeavor. So put in simple terms, this visa is for individuals at the very top of their field. And this can be demonstrated through two different avenues. You can either show a one-time major international award or fulfill at least 3 of the 10 criteria stipulated in the codified regulations. So to start, let's talk about the one-time international award. Examples of these are Nobel Prize, a Pulitzer, or a similar internationally recognized award for an extraordinary accomplishment. And if you choose to go the 3 of the 10 criteria route, it's important to remember that meeting only 3 of the 10 criteria alone is insufficient if those factors do not show support for extraordinary ability. So when USCIS evaluates the evidence you present, they'll look at the totality of the evidence. They'll put it all together and decide whether it reflects extraordinary ability. So here on the slide are a list of the 10 criteria that you can use to qualify. We'll be going over these a little bit more in detail. So criteria 1 is an awards criteria. A petitioner may present evidence of receipt of lesser nationally or internationally recognized prizes or awards for excellence. If you don't have a major internationally recognized award, such as the Nobel Prize or a Pulitzer, this is where you can provide evidence of other awards that can also support a finding of extraordinary ability. These awards must be nationally or internationally recognized. They should be issued by respected organizations with stringent and selective processes. They must align with the field of your endeavor, and they must be awarded for excellence. Typically, awards limited to local, student level, or academic scholarships don't qualify.
You can even add corporation awards to that. Things that are just typically within the corporation itself instead of industry-wide. The USCIS is increasingly less excited about those awards. They're requiring a higher level of industry, clear industry impact.
Yeah. And I also want to note there was a fairly recent update where they're accepting team awards as well, but each member must be officially recognized within that award. So if you're working on a team and you've received an award, that may be evidence for criteria number 1.
Amazing.
All right. The second criteria is regarding memberships. So a petitioner may present evidence of membership in associations requiring outstanding achievements in the field for which classification is sought. So to break this down, for a membership to qualify, the membership must be with an organization or association that requires exceptional achievements from its members, and the membership eligibility must be judged by nationally or internationally recognized experts. Any documentation showing active involvement with an organization at the time of membership is very persuasive for an EB1a application. Additionally, evidence of specific selection criteria is necessary to show how prestigious the membership would be. Past memberships can qualify. However, more up-to-date memberships are very persuasive, and it must be connected to your field. The memberships cannot be solely based on payment or general qualifications. So it needs to show that you do have some extraordinary ability to be able to qualify for the particular memberships you present.
Exactly.
And criteria 3. So this one's regarding publications about the petitioner. So a petitioner may present evidence of published material about the petitioner in professional or major trade publications or other major media. So there's a little bit of criteria here. The publication must be printed or published in professional or major trade publication in an established media source with high circulation and ranking in the country. It must contain content primarily focused on the petitioner and their work. Also, the publication must contain the date, the title, the author's name, and it can be in any media form. It could be printed, it could be video, or it could be audio, which opens the door for more avenues for you to present evidence. And I want to note that the most impactful publication evidence will discuss the industry impact and highlight individual contributions to the field. This will be very strong evidence for your case. Moving on to criteria 4. This is participation as a judge. So a petitioner may submit evidence of the petitioner's participation as a judge of the work of others in the same or allied field for which the classification is sought, either individually or on a panel. When judging another's work, you must show an invitation to judge another's work and participation in the judging of the work. And it must be the same or allied field. So some examples include reviewing academic papers, serving on panels, evaluating grants, judging competitions, or other like judging situations. Some evidence for this criteria include if you received official invitations or emails or letters confirming selection, and proof of achievements that led you to being selected.
Right.
And evidence of participation can include some redacted forms of reviews, acknowledgement letters or certificates, and participation letters. The criteria.
The judging is really a great way to distinguish yourself if you are looking to become an EB1a petitioner. I really think that right now the USCIS is finding a lot of value if we can find the appropriate evidence to show that you did meet the judging criteria. They really want to, as Alex mentioned, see that you are working within your field, see that you are really, it's even better if you're working within your niche area. So if you are a neuroscientist and you are working, evaluating neuroscience journals, like they're kind of in your area, that is very valuable to the USCIS, very compelling evidence. So you'll notice that in EB2, sometimes evidence can be that you have peer reviewed for scholarship journals. Sometimes it can be compelling evidence for both criteria, and what you find yourself in this situation where you have to evaluate the totality of your evidence and your circumstances to then decide whether you should apply for the EB1 or the EB2. So the judging framework is, in my opinion, is one of the more compelling areas if you're looking to improve or enhance your portfolio. Getting involved in this capacity could be something that really elevates your application or petition to the next level.
Yeah, I second that, and it's all great advice.
Yeah.
I do want to note that when judging for criteria 4, if you're paying to review others' works or you're judging work that's just completely outside of your field, that's not evidence that will strongly support a finding of extraordinary ability. Absolutely. So you want to be a judge on the merits.
Yes.
All right. That takes us to our next criteria, criteria 5. This one's original contributions, so it's a bit more open-ended. A petitioner may present evidence of a petitioner's original scientific, scholarly, artistic, athletic, or business-related contributions of major significance in the field. For this criteria, the work must be unique, innovative, original, and it must be of major significance in the field for which the classification is sought. So I want to provide a couple examples of this. So if you're a scientist or researcher, you could use peer-reviewed publications and citations to demonstrate your contributions. This also works for other criteria as well. Artists and performers may present media coverage, exhibition records, or industry awards. Business leaders, they can provide evidence of leading a company to groundbreaking achievements, creating significant industry innovations, or being featured in major business publications. This is not an exclusive list. There are plenty of ways to show original contributions to the field. And this is kind of a catch-all for the criteria. It's where you can really show, all the contributions you've made that may not fit into the neat categories of the other 9 criteria. That takes us to criteria 6, which is authorship of scholarly articles. So authorship of scholarly articles in professional or major trade publications or in other major media in the field. Evidence for this includes peer-reviewed or cited works in reputable journals or major trade publications. The articles themselves should be scholarly in nature and demonstrate ongoing influence. The best way to demonstrate influence is through citations and usage of the findings from that article.
Yeah, especially if you can prove that other scientists that you do not directly collaborate with are citing to your work. The USCIS finds it more compelling to have those independent citations, is what we call them, and to make sure that it's even better if leading scientists in your field are choosing to cite to your work and incorporating your findings into their platform. That would be compelling evidence for this criteria. Demonstrating that ongoing influence that's beyond yourself, beyond your employer, is huge for them. You could also kind of tap into the basis of the funding for your research. Are you part of like a broader, federal funding kind of situation? We could potentially leverage that to also demonstrate that influence in the field if it's part of a larger program that is, federally funded.
Yeah. So kind of piggybacking off of what Chelsea said, the more citations, the better. More articles is better, but they really do look to that influence. So citations are just an easy way to demonstrate some influence. Also, if the article is circulated internationally or at least nationally, those are more persuasive as well. Which takes us to criteria 7. So this is works displayed at exhibitions. This is typically useful for artists who have publicly displayed their works. So the work must be of the petitioner's own creation. It must also be the petitioner's primary work, and the venue must be an artistic exhibition or showcase. That one's
I think that's one thing that's really interesting to me about the EB1a, Alex, is that in comparison to the EB2, the EB1a has opportunities for artists. It has opportunities for athletics. It has opportunities for scientists, people making breaking research in their field or contributions to their field as a whole, which I think is really unique. If you can meet that criteria, this is definitely a unique factor for the EB1 compared to the EB2. And we won't spend a lot of time talking about the EB2, but a lot of people come with questions about both at the same time. So the EB2 is a little bit more limited and a little bit more restrictive in that sense, that they tend to have a pretty distinct preference for STEM related fields, especially kind of like the healthcare, public health issues. Those issues tend to be very favorable right now. So and that doesn't pigeonhole you, but I'm just saying that the EB1a to me is very neat because, and you'll see kind of peppered throughout the 10 criteria, is that there's opportunities to meet it based on your field. So this criteria 7 is something that kind of circles back and loops in artists because they probably don't have publications, right? But being honored in like something like this exhibit would be a demonstration of highly influential progress in your field or innovative progress in your field. Similarly, you probably don't have publications as star athlete, but maybe if you represented in the Olympics or on a world platform, like maybe that would be compelling. If you achieved a podium award or some kind of innovative like EBSI award or just whatever it is in your field that could be leveraged, then I think that that's neat for the 10 factors. That's something that allows you to kind of find your niche and navigate this journey for yourself. And the fact that you only have to have 3 of the 10, compared to the EB2 where you have to have, there's only 6 factors and you have to have the 3 of the 6 factors. So just distinguishing for us a little bit here, how the 10 criteria, it gives some flexibility based on your industry, because in the EB1, there is a bit more express flexibility for your industry.
Yeah, that is one thing that's nice about the EB1A is it does allow for a lot more flexibility, whereas NIW, they really do look to, a couple of industries that they want to focus on. So it is a great opportunity.
Sure. It's still a higher standard. And we can talk at the end. There is a little bit of peppering of the expectation into the EB2 as well, but the EB1 still is a distinguished criteria from the EB2. We're just kind of drawing a little bit of comparison for you along the way here.
Yeah. All right. And moving on to criteria 8. So this one's assuming a leading or critical role in an organization or establishment with a distinguished reputation. So to play a leading role means being involved in leadership with either organization or the division. A crucial role would mean contributing significantly to key outcomes that are critical for the organization or establishment. And I do want to note that the organization should have a distinguished reputation. Also, evidence for this criterion will generally come through letters or other verifying materials, and it should describe the leading or critical role and should be paired with evidence of the organization's reputation, and that should paint a nice picture to successfully meet this criteria. So criteria 9 is high salary or remuneration. So commanding or holding a high salary for services relative to others in the field. The evidence should show that the salary of the petitioner falls within the top region of the top 2 to 5% in the region where the petitioner works. Base salary is considered as evidence. Bonuses can also qualify as part of this evidence, but only if you have an actual receipt of the bonus and they are included in the total wages section on your tax return. I think it's important to note that benefits are not included as supporting evidence for this criterion. So that would include items such as tuition reimbursement, healthcare, medical allotments, and profit sharing incentives, and items like that. What they want to see is like hard documentable evidence. So tax returns are a good place to show that, pay stubs as well. And moving on to the last of the 10 criteria, commercial success in the performing arts. You'll typically see this with singers, performing artists, musicians, actors, individuals in those types of fields. So evidence of this can include sales, box office success, or other comparable measures. And what we really want is the petitioner to be closely tied to the commercial success. So let's say you're in a film and you're playing a leading role. Well, I think it would be pretty closely tied to the success of that film. Whereas if you're just like a background extra, there's not really a way to show that, you made the movie successful.
Correct. Yeah.
And
if you were invited to work at, present your film at like the Sundance Festival that happens each year, or some of these more exclusive, honorary, even if it's small film awards, if you're working on a documentary that's like bringing in some new insight or creative input into the field, and you get invited to some of these more exclusive film festivals or awards opportunities, and you're performing like a central role to the film production, you can't just like have your name in the credits. You need to be like a producer, a director, or a leading cast member or something along those roles, and then you want that role to really fit into your exceptional ability. So if you're an actor but you are a scientist, like that, you can see the contrast isn't really that exciting for the USCIS because they're not going to find a close enough connection. But maybe you're performing in a scientific-based movie, so then maybe there is an option to come back in with that exceptional ability or extraordinary ability. So just keep in mind that there always should be a connection to your central skills, to your extraordinary abilities as a professional, and to your future plans of working in the United States. So if you want to work as some kind of distinguished engineer or researcher of some kind, then keep that in mind as you are collecting your evidence or evaluating your case, because everything should come back to that very extraordinary skill set. And that would be the evaluation process that the USCIS follows as well.
Mm-hmm. Yeah, and I do want to reiterate that, the minimum requirement is fulfilling 3 of the 10 criteria. But regardless of the amount of criteria you meet, it must add up to a showing of extraordinary ability, meaning that you're at the top of your field.
Exactly.
Some people will apply, they're like, hey, I meet these criteria, but it doesn't quite get them to extraordinary ability. So just be mindful of that.
And one thing that our law firm offers, if you are looking for confirmation of your, of your portfolio, is we offer free evaluations on our webpage. You can go to our webpage. You can click on free evaluation. We offer EB2 and EB1 evaluations. Our team will, you'll put in certain information, provide your resume. Our team will evaluate that and give you some feedback. We also use those for prospective clients to determine if we could, issue a retainer agreement, if that's how that naturally progresses. That is a tool that we use often. We find that it's very helpful for the community as well. So we invite you to take a look at that evaluation, take a look at our resources. We do provide a lot of information in the Q&A section as well. So that can be a helpful source of information for anyone wanting to learn more. Just so, it's something that people often come to me and they say, hey, can I file EB1 and EB2 at the same time? And the answer is yes, you actually can. Can you, if you say like, hey, right now you don't really meet the EB1 criteria, but you definitely have a strong EB2 case, you can definitely use your, you can go ahead and file for the EB2 case. And then as your credentials improve, or you continue to do things in your field that distinguish you further and further to that extraordinary ability criteria, You can then use your priority date from your EB2 for your EB1 if you later get that approved. So there's a lot of advantage and flexibility between the two applications. If that's something that you want to discuss more, we can certainly, you can reach out to our team. We're happy to help the best we can. But today we just wanted to really introduce the EB1A. We've talked a lot about the EB2 recently. So we wanted to introduce the EB1 and give some baseline information about that. We do see that people, prospective clients or clients come to us and they say, hey, like I was issued an RFE for my EB2 and it really reads like an EB1 to me. And the answer is it might a little bit. And the reason is because the USCIS is redefining that evidentiary standard for the EB2. We saw a large influx of petitioners, so naturally they are able to be more selective, and it's a bit necessary to be more selective with so many larger pool of applicants. So we're seeing a little bit of that language kind of bleeding over into the EB2. So that's causing people to naturally become more confused about the EB1 versus the EB2. And with that in mind, I do always recommend to consult with an immigration attorney if you plan on making any kind of plans for yourself. I think that especially in the changing landscape, we're at a time where things are changing rapidly. So it is great to consult with an immigration attorney and to get some individualized advice, because what we're doing today is for educational purposes. We're really just trying to teach and explain and give you some basic understanding. Anything case specific, we would, highly encourage you to get individualized help for that. And so with that, if there's any questions or any further remarks from Alex, we can certainly, finish her conclusions and then we can take some questions before we wrap up.
Yeah, that concludes my presentation. There's the 10 criteria. I recommend you guys go just Google EB1A criteria and pull up that list. It'll be a nice reminder of the different items you can use to qualify. And you can kind of gauge and see where you would fall. As Chelsea said, we have forms on our website you can use as well.
Perfect. Nancy, I don't see any questions on my side. Do you see any questions for us today?
Hi, how are you?
Hi.
Okay, so thank you so much for this insightful presentation. Now we can open the floors for question and answers, and to make this live very interactive. And so if you all have any questions, please do comment and we will directly give them to our guest.
Perfect.
Yeah. Until that, I do have a question. So
Sure.
I believe that you have explained 10 criteria, right, of US CIS. So is it like anyone, like any extraordinary person, let's say cricketer, scientist or anything, they have to meet all 10 criteria, or there is some catch in that, or let's say they have to meet some criteria from that?
Go ahead, Alex.
Yeah, so there's the 10 criteria you can meet. You're only required to meet a minimum of 3 of the 10. So this allows some flexibility. So if you're a cricket player, awards would be a good one for you. You could meet that under, I believe, criteria 1. You also may be involved in some memberships or participate as a judge, or you just have original contributions. So as a cricket player, I would think that you could be evaluated under many of the 10 criteria. But again, only 3 is required, and you must show that you have extraordinary ability with the criteria you present as evidence.
So can you tell me what is the strong evidence for EB1A to
Strong
present?
evidence is really going to be subjective based on your field, your industry, your personal, portfolio. I think that same with the EB2 here, you'd want to look at your resume and your credentials and just really choose the things that are the strongest for you. So there's no one piece of evidence that is the strongest. But again, what the USCIS is really going to be focusing on is that broader impact. How have you distinguished yourself? So if you have a membership that really isn't highly selective, but maybe you have some judicial experience, maybe you have some awards and high salary, there's nothing wrong with leveraging all four things, but just know that you really need to focus on making sure you have the stronger evidence available to you. And so strong evidence is just going to be looking at those 10 factors and finding primary sources for things that really demonstrate that you've met that criteria.
Perfect. Okay, so there is a client who is telling, hello, I'm from Bangladesh. I believe he wants to ask a question, but let's wait for the question. Until that, okay, can you tell me the main difference between EB1A and EB2 NIW? Like, what is the main difference which, makes the both of them like kind of a different from each other?
Sure, that's a great question. So EB2, as we've mentioned, is exceptional ability, whereas EB1 is extraordinary ability. And then, of course, it's codified. It's the Donister case is the leading case for EB2, and it tells us that there's a three-factor analysis that looks at that proposed endeavor, which is the statement of the future plans. And the EB2 provides a path to green card for an individual who is making strides in their field. They are distinguishing themselves, but they're really not quite to that threshold of they're showing some broader impact. They're starting to get some traction, and you're starting to see where they're really gaining momentum, but they haven't quite met that threshold for extraordinary ability. So think somebody maybe younger in their field, maybe somebody kind of newer in their field typically is where we see EB2s. Now, EB2s can also, I shouldn't say that as a blanket term, but what I mean is that, think of somebody who is just got their PhD, they've been in school for all of these years, they have several research publications under their belt, but they're only in the field for a year or so working. Whereas typically what we see for an EB1, if the person already has their PhD and they've been working in the field for 5 or 6 years, they're gaining international awards, recognition, memberships that they were previously not really eligible for those higher earning, higher kind of award achieving positions. That's kind of what we look for, is a little bit of an objectively subjective differentiation based on your field, based on your experience, based on the things that you have been able to accomplish in your time in the field. And all of that to remind you that it's not limited to a certain amount of years in the field. That's not a criteria at all, but it's just a broad generalization to give you some understanding of where that may kind of fall within a spectrum of experience.
Perfect. Thank you so much for answering that. And with that, I would really thank you, Chelsea and Alexandria, sorry for that, for this insightful session. And thank you everyone watching us and joining us today. If you like to learn more about EB1A or any other immigration options, please reach out to rajulaw.com and have a great day, and we will look forward to see you in another next session, which is happening on every Monday, 7 p.m. GST Dubai timings. Thank you everyone, and see you next time.
Thank you for having us. Great
Thank
job, Alex.
Thank you. You too.
Hi everyone, welcome to this week's immigration update from Raju Law. We bring you the latest news, USCIS updates, and policy changes that matter. This week's top stories include the government shutdown and its impact on immigration,
new travel fees for I-94, stay, and EBAs, Pope Leo's remarks on US immigration policies, the possible reopening of DACA applications. Let's begin with the shutdown update. After lawmakers failed to pass funding, the government shut down. USCIS remains open since it is free-funded, so green cards, naturalization, and work permits continue. But Department of Labor filings pause, E-Verify goes offline, and immigration courts face delays. Next, a major update for travelers. Starting fiscal year 2026, US travel fees increased. I-94 at land borders rose from $6 to $30. Stay went from $21 to $40. And EBAs for Chinese travelers now cost $30. These fees will rise annually with inflation. Now to criticism from the Vatican. On Tuesday, Pope Leo condemned President Trump's immigration policies as inhuman, questioning their consistency with Catholic pro-life values. He highlighted contradictions between opposing abortion and mistreating immigrants. Since his election in May, Leo avoided politics but broke silence on immigration. Finally, updates on the DACA program. The federal government could soon reopen DACA for new applicants nationwide. If approved, USCIS will accept new and renewal applications, though Texas residents remain barred from work permits. Advocates estimate over 1 million new applicants alongside 533,000 currently enrolled. That wraps up this week's immigration updates. Stay connected with Raju Law for more news, insights, and guidance. See you next week with the latest developments in US immigration.